Once again, this is the webinar entitled FEHBA Subrogation Update 2017. Again, I am Doug Lehrer, and Tim Mentkowski will also be presenting with me, and we are with the law firm of Matthiesen, Wickert Lehrer in Hartford, Wisconsin. The emphasis of our presentation today will be to update you on the status of a number of cases that are currently before state and federal courts involving the Federal Employees Health Benefit Act of 1959, which is also known as FEHBA. For years, a great debate has raged over whether state anti-subrogation laws, such as the Made Whole Doctrine and the Common Fund Doctrine and others, are properly preempted by FEHBA. As we will discuss, there has been serious conflict over the past few years regarding which provisions of FEHBA can preempt state laws, as well as which state laws can be preempted. This webinar will provide an overview of the ongoing conflict from a statutory, regulatory, and litigation background to the current status of some of the most important cases that are currently on appeal and on remand. Some of the cases that we will discuss today include the Helfrich versus Blue Cross and Blue Shield case out of Kansas, the KOBOLD versus AETNA case from Arizona, the Nevels versus Group Health Plan case out of Missouri, and finally the Bell and Blue Cross and Blue Shield case out of Arkansas. A basic knowledge of each of these cases is important to fully understand where we have come from and where we are going on the exciting topic of FEHBA subrogation and reimbursement. Before we discuss each of these cases in detail, I think it is important that we first give a brief history and background of FEHBA. FEHBA was enacted in 1959 as a comprehensive statutory and regulatory scheme to establish the Federal Health Benefit Program and govern a comprehensive program of health insurance for federal employees. This act can be found in 5 U.S.C. sections 8901 through 8914. It is basically the federal employees' counterpart to ERISA in the private sector. We're not going to talk a lot about ERISA today. That is a topic for another day. But it is important to note that there are a lot of similarities in regards to preemption and subrogation matters with ERISA and FEHBA. In any event, turning back to FEHBA for a minute, the U.S. government sponsors more than 350 different health plans, which covers more than 8 million federal employees, retirees, and beneficiaries through FEHBA. These health plans are administered by the Office of Personnel Management, which you'll hear a lot about today. It's also known as OPM. And what FEHBA does is it charges OPM with negotiating contracts with private insurance carriers to provide an array of health care plans. By enacting FEHBA, Congress sought to ensure that these health benefit plans offered to federal employees would provide uniform coverage and benefits regardless of the state in which an employee lives. FEHBA also established an administrative mechanism for OPM to review claims and to make regulations necessary to carry out programs and provide for operations. Under FEHBA, the federal government does not serve as a health insurer. Rather, it utilizes OPM to contract with private health insurance companies on behalf of its employees in order to provide them with health plans which comply with and provide benefits under FEHBA. The Act also requires that contracts between carriers and the OPM have statements of benefits sections which describe such things as maximum payments, limitations, and other clauses which are generally found in other health insurance plans as well. In addition, one of the provisions in these contracts requires the insurance company to subrogate in cases where another person or entity causes an injury or illness to an insured, resulting in these plans making payments of benefits under FEHBA. We will discuss that in more detail shortly. Let's next turn to the topic of preemption as it relates to FEHBA subrogation and reimbursement. First, it is important to note that FEHBA itself, the Act itself, does not specifically mention or provide for rights of reimbursement or subrogation. Rather, all subrogation or reimbursement rights must be provided for in the terms of the plan or contracts involved. Whenever I receive a FEHBA matter in, the first thing I do, or one of the first things I do, is look at that plan language to make certain that it has the effective subrogation reimbursement language, which we'll discuss momentarily. In any event, turning back to history of FEHBA, in 1978, in order to ensure uniformity in the administration of FEHBA benefits, Congress amended FEHBA to include for the first time a preemption clause. And that original preemption clause, which is not the one that's in place today, but the original one stated simply that state and local laws and regulations were preempted only where they were, quote, inconsistent with such contractual provisions, end quote, established under FEHBA. Problems arose, however, in the 80s and early 90s when some courts rejected FEHBA preemption if the state laws were found to be consistent with FEHBA, and decisions on the extent and scope of FEHBA preemption varied from jurisdiction to jurisdiction, resulting in a split of authority. Therefore, in 1998, Congress amended the preemption clause in an attempt to cure that split of authority, and the amended preemption clause, which is in front of us, it's on our screen right now, remains in effect today. It's an important part of the topic we're going to discuss today, so I'm going to read it, and then we can break it down in a moment. This provision, which is found at 5 U.S.C. section 8902, paragraph M, paragraph 1, provides as follows. The terms of any contract under this chapter which relate to the nature, provision, or extent of coverage or benefits, including payments with respect to benefits, shall supersede and preempt any state or local law or any regulation issued here thereunder which relates to health insurance or plans. Now, before we break down this preemption language, let's first discuss why the issue of preemption is so important when it comes to FEHBA subrogation and reimbursement. As many of you know, many states, including Wisconsin, where Tim and I are located as we speak, there are strong anti-subrogation state laws which can limit the ability of subrogated carriers to pursue subrogation and reimbursement out of personal injury settlements. For example, Wisconsin laws provide that a subrogated health insurance carrier generally has no rights of subrogation. There are exceptions to that, but the general rule is that they have no rights of subrogation unless their insured is first made whole by a settlement. Again, that's under Wisconsin state law. This state law, if it applies, can limit or even extinguish a subrogated carrier's rights to recover benefits paid out to their insured when they recover from a third-party tortfeasor, again, unless the carrier can show that the state law is preempted by contrary federal law. Turning back then to the preemption provision, preemption applies under FEHBA only if all of the following things can be shown. Number one, that the terms of the contract provide for preemption of state laws. That number two, those terms relate to the nature, provision, or extent of coverage or benefits, and that's an important phrase which we'll go into detail momentarily. And then finally, number three, that the state law, which is being preempted, relates to health insurance. It is those issues which is the basis for most of the litigation that we will discuss today. Now, before we discuss the recent cases that were mentioned earlier in this presentation, I do think it is important to briefly discuss the 2006 Supreme Court decision of Empire versus MCVEIGH. In the case of Empire, the OPM, in accordance with FEHBA, negotiated a health insurance plan for federal employees in New York with Blue Cross Blue Shield. That plan required the administrator of the plan to make reasonable efforts to recoup amounts paid for medical care for beneficiaries if those beneficiaries received recoveries from other sources such as in a lawsuit or settlement against a third party that caused injuries. The plan in question here was administered for New York employees, federal employees, by Empire, which was a New York insurance company. Joseph McVeigh was a New York federal employee who was insured under this plan, and as a result of an injury that he sustained, the plan paid over $150,000 in medical expenses when, again, he was injured by the negligence of a third party. McVeigh brought a tort suit in state court in New York against the third party alleged to have caused the injury, and that case settled. Empire then filed suit in federal court seeking reimbursement in the amount of medical expenses it paid to McVeigh. It's important to note that the issue in McVeigh was not whether FEHBA authorized preemption of a state anti-subrogation law. Rather, the issue in McVeigh was whether under FEHBA, a suit brought by an insurer against an insured to recover medical expenses could be filed and heard in federal court. In a 5-4 decision authored by Justice Ginsburg, the court in the Empire case held that jurisdiction lay in state court and not in federal court. Justice Ginsburg pointed out that while FEHBA stated that any claims against the United States would be heard in federal court, it further stated that under FEHBA there were no provisions for suits brought by insurers seeking to recover medical expenses from private beneficiaries be filed in federal court. The court also held in this case that absent a specific provision in FEHBA, a significant conflict with an identifiable federal interest or the need to resolve a substantial question of federal law in order to establish the insurer's right to recover, there was no reason, the court held, to allow state court breach of contract claims to be heard in federal court. As such, in the Empire case, the court dismissed the federal court action for lack of jurisdiction. The main reason I wanted to touch upon McVeigh today was to point out that over the years I have had many arguments with many plaintiffs' attorneys who have attempted to argue to me that McVeigh holds that ERISA does not preempt state law. That's simply not what McVeigh says. Rather, the holding in McVeigh is simply that the federal court did not have jurisdiction to hear the case under FEHBA, and it should have been heard in state court. Before we continue with an overview of the more recent case law, and I'm going to turn this over to Tim to proceed from there, we would like to now give out our trivia question for today. As Tim had mentioned, the first person to give a correct answer to the trivia question will win one of our books, and we'll announce the winner at the end of our presentation today. The trivia question today is as follows. In the television series Seinfeld, what was Kramer's first name? Once again, in the show Seinfeld, what was Kramer's first name? The person who types in the answer first will win the prize. At this point, we also would like to give to those that are receiving credits in Texas, CE credits in Texas, the code word. The code word, or in this case code words, will be tippy-toe. Once again, the code is tippy-toe. So with that being said, we'll next continue with the recent case law, and Tim, the floor is yours.
All right, thank you, Doug. Everybody, glad to be back after the more exciting stuff of preliminary technical items that I went over before we got started here. But I'm looking forward to discussing what essentially is going to be a series of 4 cases that were in some of the state Supreme Courts and various federal courts around the country, and then some administrative action in the middle of that, and then this sort of all gets bounced back to the same 4 cases subsequent to that. So it's pretty interesting to sort of see how things unfold chronologically, as far as how this case law has developed pretty interestingly over the past few years. So the first case that we're looking at is KOBOLD v. AETNA Life Insurance Company, which this was in the Arizona Court of Appeals, going back to 2013. And we had a federal employee was injured in a motorcycle accident, and AETNA, who was providing the health benefits pursuant to their FEHBA contract, paid about $25,000 in medical expenses. The employee brought a third-party action against the alleged tortfeasor, which was later settled for $145,000. And because there was an ongoing dispute with regard to AETNA's subrogation rights, the defendant filed an interpleader action to have the court make a determination of who was properly entitled to those funds. And much of the reason for this is an unfortunate situation that probably most of us who work in the subrogation arena are familiar with, which is that Arizona is a vehemently anti-subrogation jurisdiction, owing to the common law bar on subrogation, an example of which is set forth here in this quote from Piano v. Hunter. The common law rule in Arizona is that absent a statute, an assignment of a cause of action for personal injuries against a third-party tortfeasor is void and unenforceable. So this is kind of your general bar on splitting causes of action for personal injury. It's a relatively common thing that you see in the anti-subrogation jurisdictions, especially the ones that are common law based. So it's either splitting causes of action or assignment of third-party claims, but that's one way that a lot of the jurisdictions tend to go about barring subrogation for health benefits, mostly. So the court, having considered the various arguments, namely AETNA was asserting that their contract language or their policy language that overrode the May-Hold doctrine, they said that that preempted this anti-subrogation state law in Arizona, and therefore they were entitled to the recovery as set forth in the contract. Obviously, the insured person disagreed. So part of the reason that Doug went over MCVEIGH earlier is that it tends to factor into a lot of these decisions that we're discussing, even though anybody who's read the case closely, I think, is pretty familiar with the fact that it's not a ruling on whether FEHBA preempts state law, in the subrogation context. It really was just a case regarding federal jurisdiction. Notwithstanding, as Doug noted, it has been thrown around by plaintiffs' attorneys quite a bit to try and extinguish subrogation interests, on recoveries for their clients. So I think that's the way it found its way into these decisions. Obviously, it was probably briefed a lot, but one of the things that gets noted most often is the section in that decision that recognized that there was, potential for alternative interpretations of the FEHBA preemption statute. And one of the reasons that that is pertinent is because there are some common law, sort of federal common law or state common law principles regarding preemption issues, which is that there is preemption is disfavored as a matter of sort of promoting state rights and all these issues of federalism and stuff, which are have been quite popular in the political arena for the past few years as well. So it kind of makes it an issue of states' rights versus federal government control, which is a little more fascinating with that spin on it. But it's disfavored. We don't like it. So if there are two plausible readings of a statute, then the court has the duty to accept the reading that disfavors preemption. So if there's two plausible ways that you can look at a statute, and one of them does not support the notion that state law is going to be preempted on any given topic, then they have to defer to that reading of it, and state law is not going to be preempted. So here, their interpretation of the FEHBA preemption clause was that, let's quote, relate to requires some sort of direct and immediate relationship. You know, it's not broadly construed as you might see in the ERISA context, which is an entirely different animal, but it does get mentioned sometimes. And that is sort of a broad interpretation that they would use as far as, you know, whether or not a law relates to employee benefit plans or something like that. You're not seeing that here. Here they're saying we're going to go much narrower on the scope of relate to, so it's got to be more specific as, you know, to dealing with particular benefits. Coverage, they took as the scope of the risks insured under a plan or policy. So that's relatively straightforward, not broad interpretation either. Benefits, they interpret it as financial assistance that the insured receives as a consequence of the coverage. So again, that's a very straightforward look at the term, very dictionary-esque. It doesn't really allow much for a sort of more creative reading of it than might have us considering things like tort settlement proceeds and reimbursement. Specifically noted that it does not include tort settlement proceeds, which obviously is not good for subrogation people. So in looking at all that, they decided that the subrogation provision in that contract or policy bears no immediate relationship to the scope of coverage or receipt of benefits. And thus, because it does not have the immediate relationship, it doesn't have the necessary connection to the preemption clause, and therefore it just doesn't apply in that situation. As they noted, the provision, they said, does not have an effect on an insured's right to receive benefits when he or she suffers an illness or injury. It's more sort of a subsequent thing that comes into play. And there also was an issue in this one where the OPM issued a letter, not a formal rule, but kind of an informal opinion letter that you might see from like an attorney general or something like that, stating that their interpretation was that subrogation does fall under the guise of the preemption statute, but the court said it's just a letter, we don't have to listen to it, it's not any sort of regulation or law, it doesn't matter, we're not going along with that. And thus they said Arizona anti-subrogation law was not preempted and the carrier was not allowed to recover. Next is a case of Neville's versus Group Health Plan, Inc. I think this is probably the big one out of all of them, but this is, came next chronologically. Here we had a employee or a federal, I guess a beneficiary of a federal plan, injured in a motor vehicle accident. Group Health Plan asserted a $7,000 lien against the settlement. The insured paid it, but then later, after having paid it, instituted a class action against Group Health Plan, saying that they incorrectly asserted that right to recovery. Which is a little backwards, but you know, sometimes it's the way people like to do things. Missouri's anti-subrogation law is very similar to Arizona. It's common law based, which is that subrogation in personal injury cases is against public policy because it's an impermissible assignment of the insured's right to a cause of action for suffering a personal injury. So again, this is the assignment issue. I don't know how far back that doctrine goes, but it's probably you know, somewhere in merry old England in the time of kings and separated equity courts and all sorts of wild stuff like that. It's quite an issue anymore, but in some of these states it is. Again, they looked at MCVEIGH, you know, and they have this presumption issue saying that if there's two plausible readings, then again, we have to look to the reading that disfavors preemption. So we're going to err on the side of not preempting state law. So looking at MCVEIGH again, even though it's a jurisdictional case, they recognize that it said there was two plausible interpretations, and they also noted, there's a little snippet in there, that purportedly distinguishes the issue of subrogation from the concepts of coverage and benefits. So they say they're not really the same thing, there's a disconnect there, which is something that a lot of these decisions kind of pounced on. So they said relate to, referring back to the KOBOLD decision, requires a direct and immediate relationship to the insurance coverage and benefits at issue. Direct and immediate relationship, again rejecting the broader interpretation of relate to. Benefits, they noted, are distinct from the insurer's right to pursue subrogation against the insured's recovery from a third-party tortfeasor, which I think they were kind of thrown back to, you know, some dicta noted in the reasoning of MCVEIGH, but they really jumped on that and said there's no connection between subrogation and you know, this issue of the payment of benefits or coverage. So what they said, and I find this a little odd, but you know, more or less what they said was the fact that a subrogation right is triggered by payment of benefits doesn't mean it relates to the provision or extent of benefits. So I think it's a little odd, you know, just because I underlined the parts where if you read those taken together, it seems a lot more counterintuitive than when you look at the whole thing. But basically, your subrogation right is triggered by payment of benefits, but somehow that doesn't relate to the provision of the benefits. How does that happen? I don't know. But that's what they decided. They are the learned judiciary of the fine state of Missouri, so who am I to disagree? Anyway, they held, not surprisingly, that Missouri's common law rule against subrogation was not preempted by FEHBA. The later case now of Helfrich versus Blue Cross and Blue Shield Association, this comes out of the District Court of Kansas. We're in federal court now, where we've got an air traffic controller was injured in a car accident. Blue Cross Blue Shield paid about $75,000 in medicals. The insured settled for its $100,000 policy limits. So obviously that's going to be a bit of a problem for everybody when there's not enough going around. They probably wouldn't even leave the plaintiff's attorney with a fee, or not a whole one anyways, unless he was being rather gracious with his contingency rate. This stems from a Kansas administrative regulation as opposed to common law, so that's a little different. But basically it said no insurance company can issue a contract of insurance in the state of Kansas with a subrogation clause or any other policy provision having the same purpose or effect applicable to coverage providing for reimbursement of medical, surgical, hospital, or funeral expenses. So as opposed to saying there's some sort of, you know, bar on assignment of personal injury actions, they kind of just went the more, not statutory, but regulatory route in saying that you just can't have those clauses in there. This court, a federal court now, did distinguish MCVEIGH as being a jurisdictional case. So they said that's not really dispositive here and we're not going to give it an undue amount of weight. They also noted that, okay, yes, there is in some cases a presumption against preemption, as we discussed in the last two cases. They said, however, that can be overcome if the congressional purpose of preempting state law is clear. And they do not have to automatically accept any plausible reading that disfavors preemption. So they're giving themselves, the court, a little more discretion interpreting this. It's like if there's any sort of, you know, tenuously colorable construction that might go against preemption, they don't have to automatically accept that. Now, if you look at this relate to here, they said that's got a much broader interpretation in the federal court. They said, well, it's a connection with or reference to. That's more similar to what you would find in, say, the ERISA case law. They specifically rejected this narrow standard put forth in KOBOLD and Neville's, and they noted that the congressional purpose here, which was clear, was to ensure the uniform nationwide interpretation of health insurance plans so that issues like reimbursement are not going to vary depending on where the insured resides, which I guess I'm probably biased on the side that I'm on, but that makes a lot of sense to me. It probably would make sense to me if I was a participant in one of these plans. But anyways, that's what they said the purpose is, and so that's going to be justifiable to overcome the presumption against preemption, and hence they said Kansas regulation disallowing subrogation is preempted by FEHBA, and thus the carrier is allowed to recover. Bell versus Blue Cross and Blue Shield, this happened subsequent to that in 2014. This is in the Western District of Arkansas. Again, we're in federal court. We had a nurse working for the VA hospital was injured in a motor vehicle accident. Plan paid about $33,000 in benefits, and the insured settled with a third party for an amount that doesn't appear to have been disclosed. But Arkansas has got a made whole doctrine. We're going back to common law now, but it's a little different from a complete bar on subrogation. This is, going back to the made whole, which I think Doug discussed pretty judiciously earlier. But this is an insured should not recover more than that which fully compensates. An insurer should not recover any payments that should rightfully go to the insured so that he or she is fully compensated. And I think probably in the entire history of the made whole doctrine, there's probably been, the amount of people that have been made whole, you can count on one hand, I'm willing to bet. So their discussion of FEHBA preemption, they noted that the contract terms must relate to the nature, provision, or extent of coverage or benefits. Okay, this is going back to the actual language of the statute. And the state law at issue must relate to health insurance or plans. So, discussing MCVEIGH, they noted that the FEHBA preemption clause is susceptible to multiple readings. So the court here has to decide whether the clause relates, quote unquote, to coverage or benefits. And we've seen how that's gone a couple of different ways in 3 different cases so far. And like the Helfrich court, the Bell court decided that they were not going to accept this narrow reading put forth in KOBOLD and Nevels, which was the Arizona and Missouri cases, holding that the connection has to be direct and immediate. They're going for a broader approach. They said was, when a carrier's demand for subrogation is separated in time from the carrier's initial payment of benefits, the contractually defined subrogation rights of the carrier can nonetheless relate to the payment of benefits pursuant to the plan. So again, this is a much broader look at it. It says, okay, maybe it's not all happening at the same time, and maybe it's not directly an issue of, the insured applies for benefits, the claim is paid, and that's pretty much the end of it, which is more or less, what the anti-subrogation decisions decided. They said, okay, but it's not an immediate connection in time, and it's a little bit more, I guess, attenuated, logically, but nonetheless, it relates to. And so they said that the conclusion is supported by other 8th Circuit precedents and federal interests of uniformity and low premiums, which federal interests were noted in the previous decision. And they also discussed the low premiums here, which is generally a very popular policy point for subrogation. So they held that the Arkansas made whole rule was preempted by virtue of the FEHBA. So we had all of those decisions, and shortly after all of that stuff went down, here's what happened. In late April of 2014, the health plan in Nevels petitioned to the U.S. Supreme Court, and then the same thing happened with the health plan in the KOBOLD case, also petitioned to the Supreme Court. So those are the 2 state court decisions. Shortly after that, Helfrich appealed to the 10th Circuit Court of Appeals. And a month after that, the United States Supreme Court, after they had granted cert, invited the Attorney General on behalf of the United States, because obviously they're going to have some sort of opinion, because this is dealing with the federal government and benefits and, sort of the OPM's interest. They wanted to get their sort of opinion on it. And then a couple months after that, then Bell appealed to the 8th Circuit, also in the federal circuits. Now, not too long after that, we've got the OPM, the Office of Personnel Management. They put out a proposed rule to sort of change the old one, but a rule to interpret what's going on, whether subrogation relates to or not. More or less the content of the letter that I discussed, I believe, in the Nevels case. They wanted to make a rule that said, okay, let's clear this up and say that our position as the regulatory office responsible for interpreting and enforcing the FEHBA, we're going to make it clear that subrogation falls under that. We're going to make it a little bit clearer here. And then I guess you could say, being on the same team, the United States filed their amicus brief filed one in Helfrich, actually, which was pending in the other federal court, not the United States, but United States Supreme Court, but they're working their way in the federal court too. The OPM published their final rule after all of their rulemaking procedures, which is very exciting aspects of administrative law that unfortunately we don't have time to go through here, but they have procedures they have to follow, and they did all of that. They published the final rule in late May of 2015. The next day, the Attorney General filed their brief in the KOBOLD and Neville's decisions, which I have not read, but essentially I'm assuming say, look, we've got this new rule. There's, obviously it's going to overcome it, and there's no reason to decide this now. It's all kind of moot. So that rule took effect on June 22nd of 2015, and exactly 1 week later, the United States Supreme Court vacated and remanded KOBOLD and Neville's back to the state courts, and the two federal decisions in the appellate courts were remaining pending at that time. So here is the new OPM rule, which is still in effect today, and this was adjusted and crafted to counter those negative decisions that they had received in essentially the state courts. And basically what it says is the carrier's rights and responsibilities pertaining to subrogation and reimbursement relate to the nature, provision, and extent of coverage, including payments with respect to benefits, okay? Specifically noting the statute, as you can see, the 5 U.S.C. 8902 M1 right in the middle of the paragraph there, said that these rights and responsibilities are therefore effective notwithstanding any state or local law or any regulation issued thereunder which relates to health insurance or plans. So they're specifically mentioning subrogation, which was not mentioned, as Doug noted, in the FEHBA. In the preemption provision, does not say subrogation anywhere. It does mirror some of the statutory language, such as the contract terms and the terms of relate to, coverage, benefits. Obviously, these were issues in the KOBOLD and Neville's decisions where the state courts found a disconnect between their narrow version of relate to and this issue of coverage and benefits. So they said, the OPM's like, we're going to shore up this gap, we're going to get everything together, and nobody's going to be able to, come up with these unfair interpretations of what we thought was the right thing all along. So in essence, they just wanted to take this, bridge the gap that was sort of being created by these interpretations of the preemption statute and these issues of state law, whether it's going to control or whether it's going to be preempted by the contract terms. So everything went back to state courts, and the other cases were pending in the federal appellate courts. Our first decision to come after the new OPM rule was Helfrich. That went back from the 10th Circuit, and they noted was that federal common law displaces state regulations, and there is a conflict between state law and federal policy, which is the federal policy to reduce premiums and increase coverage. The government's got an interest in that. There's another emphasis on the federal interest exception to the presumption against preemption, which is that they want to be able to attract good workers with these benefits and lower costs and having uniform application across states regardless of where the federal employee lives. And they found that it was the express intent that subrogation should relate to benefits. So again, we're talking about this sort of linchpin phrase of relate to, and that the OPM regulation is entitled to deference, which is yet another very exciting corner of administrative law. But essentially what it means is when an administrative body such as the OPM, or maybe you could think of the Environmental Protection Agency, or the Food and Drug Administration or something like that, they don't have the power to create statutes, but Congress, in enacting statutes and creating some of these federal agencies, will grant a certain amount of authority to the agencies or to the regulatory body to interpret and enforce the laws in a certain way. And that's where we get regulations from. So a regulation doesn't necessarily have the same force as a statute, So if there's debate about it, there's, it can kind of be overcome by interpretations that a state or federal court might have to the contrary. So question of deference is, okay, this is what the regulator thinks, in this case, the OPM, this is say this is how we read the statute, this is how we want it enforced. Generally speaking, if everything is followed in the right way and they checked off all the right boxes and it's a reasonable construction of whatever it is they're doing, then they get the benefit of the doubt on their interpretation. Unless there's something blatantly arbitrary and capricious, I think is typically what the standard is. But unless there's something blatantly wrong with their interpretation, they get the benefit of the doubt and it's going to be enforced as they interpret it. So they affirmed the lower court and upheld that decision that Kansas law is preempted and the FEHBA carrier gets to recover. So then KOBOLD came back. This is the state court. They took a look at the new regulation, and I believe there were some references to HEALTHCHOICE in there. But they again noted that the new regulation is entitled to deference as the administrative agency, which is the OPM, and they found that the OPM's broad interpretation was reasonable, even though they were one of the courts that supported the narrow interpretation. They said, okay, fine, that's what the OPM says, then we are going to follow that as a court because it was reasonable, even though we interpreted it differently. And they also noted that the regulation promotes the goals of the FEHBA, so that kind of would go against the presumption of preemption as well. So they wanted uniform treatment of insureds nationwide regardless of where they live. So they actually reversed their previous decision and reversed the circuit court and found that Arizona state law, anti-subrogation, is preempted, thus allowing the FEHBA carrier to recover. And then we have Neville's, which is the Missouri case that came back from the United States Supreme Court after promulgation and enactment of the new OPM rule. And they felt differently from KOBOLD, to say the least. It's their ruling was that the regulation does not overcome the presumption against preemption. They noted that the statutory preemption provision still ambiguous, going back to MCVEIGH, which was a jurisdictional case still. And they found, I think this kind of addresses too what was discussed in the HEALTHCHOICE decision, which that they said, this regulation doesn't demonstrate any sort of clear intent of Congress. They still think it's kind of muddled. And they got into a much more complicated issue on the deference question, because they said, well, it's different and it gets treated with more scrutiny when the provision that's being interpreted by the administrative body is having to do with preempting state law. Like, you're supposed to give it an extra sort of stringent look, and therefore they don't get the deference that was afforded by the previous 3 courts that we looked at, or 2. Disagreed with HEALTHCHOICE on the federal interest exception. They said, yeah, maybe there's some stuff, I guess, that's good for the federal government, but Missouri's got a lot of interest, too, in enforcing its laws, and essentially they said that's more important. We're the state court, not in those terms, of course. If you read the decision, you're not going to find that in there. But they more or less gave their own state laws preferential treatment in, based on the state interest that they would have, and they explicitly noted their disagreement with the KOBOLD decision on the issue of deference. So they affirmed their previous decision and the circuit court decision and still maintained steadfast in their position that Missouri law is not preempted, subrogation is barred, FEHBA or no FEHBA. And the last one that we had come out was in May 26, 2016. This is Bell versus Blue Cross, and this is the Arkansas decision, which was made whole. This kind of, just went along with the lines of HEALTHCHOICE and KOBOLD, saying that, there's this issue of the presumption. Actually, this is interesting because it sort of fires back at what was discussed in the Neville's decision, which came out not too long before this one. But they said the application of this presumption has been really sporadic, and it's not really quite as cut and dry as the previous court made it out to be. And they found that there was an exception, again, where there's considerable federal interest, many of which we've discussed before this. And so, and they noted the federal interest. Here's another point on that, it's a federal health plan for federal employees that arises from federal law. So obviously there's a federal interest there. They also noted that the issue of subrogation and reimbursement in these circumstances has a significant impact on the federal treasury and on premiums or benefits for other employees, because the recoveries going through some process eventually get reimbursed back to the federal government. So that's kind of what they were looking at there. And again, they want to attract able workers, and they want to take care of them and make sure they have good health and welfare. So whether the OPM's interpretation was entitled to deference, they said we don't even need to decide that, because even without deference, we still think that the better reading of the statute is that Arkansas law is preempted. So they more or less just said, well, we're sticking with what we said before. Even regardless of the new regulation, we don't even think it's necessary, because it was pretty clear from the get-go. Obviously, reimbursement and subrogation provisions are limitations on the payment of benefits, so thus the relate to issue. Same thing with the offset of future benefits affects the payment of future benefits and therefore relates to payments. So again noted, they reject the immediacy requirement that was discussed previously in KOBOLD and Neville's. Neville's stuck with it. KOBOLD's dropped it after the regulation went into effect, the new one. So they stuck with what they said before and held that Arkansas's made whole rule is preempted. So as far as what's going on right now, Neville's appealed to the Supreme Court on August 1st of last year. Oral argument was actually scheduled for yesterday. I've yet to verify whether that did in fact take place. I assume it does. I've not had a chance to look it over yet, but probably the transcripts are or will be available through several venues, within the next couple of days. Bell also appealed to the Supreme Court on October 11th. There was a lot of odd delays going on with this, and I'm not entirely sure why. I'm guessing probably they were trying to get it settled or something, and wanted to kick the can down the road with extending the deadlines to file their appeal, or they're rid of cert and all that. So they sort of delayed for quite a while. As of the last time I checked, which was maybe a couple weeks ago, cert had not yet been granted, and they filed a motion to expedite consideration of their application after delaying for months and months. And so this expedited consideration was denied in December of last year. I'm not sure if anything's happened in the past couple weeks on that one, but it certainly would be one to check out. So, excuse me. So that's kind of where we're at now. We've got some takeaways. I think Doug's probably got some thoughts on these items and sort of where we're at. I mean, generally, I think that the prevailing law that's out there right now is generally pretty good. You can see that 3 out of these 4 cases, have come, they're shaken out in favor of the FEHBA preemption, and Neville's kind of the outlier. But we'll have a Supreme Court decision on that relatively soon. So I'm going to turn it over to Doug to see if he's got any thoughts, and we may or may not. We'll see if we have time for questions. But we'll check it out.
Okay, thank you, Tim. I appreciate that. Tim is right. I think, as things stand today, and certainly we will keep everybody updated when decisions come down on the cases that are currently pending through our website and through our newsletters. And of course, anybody can always email us too with any questions about anything. But things certainly have been handling FEHBA subrogation matters here in Wisconsin for many years. Things have come much easier for us over the last last year or so. Since the OPM has issued their orders and decisions, and the case law that Tim discussed has come down. The hope is that it will continue to go that route, and that preemption will become accepted by plaintiffs' attorneys, at least more so than it was in the past. So with that being said, we wanted to announce our winner. We do have a winner. The question again to our trivia question was, in the Seinfeld show, what was Kramer's first name? And as probably most of you know, the answer is Cosmo. So Cosmo is the correct answer. And the first person to answer the question correctly was Brian Bargender. Sorry if I mispronounced that. Brian, you are the winner. Jamie from our office will be in contact with you shortly with information about how to receive your prize, the book. So congratulations to you, Brian. The final thing is we have a few minutes here to go over questions. And so let's do that real quick. And of course, before I do that, if anybody does have any questions, let me go to our next screen here. If anybody does have any questions that you can think of, feel free to email either Tim or myself, and we will certainly be more than happy to get at the answers to you right away. One question that we did receive, which I'll read it. It's from Tracy. Tracy Stewart. She asked, what was the percentage of the subrogation recovery in the Helfrich case? I don't know the answer to that. Tim, I don't know if you do. And if not, we will certainly send you an email with that answer. Tim, do you have any response to that?
Well, unfortunately, I don't know, but I can say that it was not discussed in any of the sort of public records that I looked at, the decisions. There may, if you wanted to look into that, you can see if perhaps there was an order enforcing that. You know, there might have been a trial court order or something to that effect that would have the dollar amount in there. But as far as what I've seen, I'm not aware of the percentage. I would guess, you know, there might be a good chance, just based on my experience, that the parties may have settled for a lesser amount than the $75,000 out of $100,000, you know, in order to forego any further appeals in the United States Supreme Court where some of the other cases have gone. So that's one possibility. But as far as the actual fact of that, I don't know. And I think Doug's got something that he wants to add.
Yes, our Jamie just mentioned that there's a second code that we need to give in regards to those that are receiving CE credits in regards to this matter in Texas. The second code to type in will be Lemon Tree. Lemon Tree is the second code. So hopefully you got both of those codes so you can receive those credits. I think we have time just for one more question. And again, please do email us with additional questions. A question I received was whether there is a difference between the preemption language in regards to ERISA versus FEHBA. And that's actually a very good question, and certainly we could spend quite a bit of time on that. We don't have that time right now, but I did want to just read to you. We've already gone over the preemption language that is found in FEHBA. The preemption language provision in ERISA, I'm going to paraphrase for you. It states as follows. It says, quote, the provisions of this subchapter, talking about ERISA, shall supersede any and all state laws insofar as they may now or hereafter relate to any employee benefit plan described in that section. I certainly in the past, more so than now, but trial attorneys have attempted to claim that while ERISA preempts any and all state laws which relate to employee benefit plans, meaning, and the argument they have made is that it's broader than FEHBA, which only preempts, quote, contracts relating to, quote, nature, provision, or extent of coverage or benefits. The arguments in the past have been that ERISA is broader. I think with the case law that has come down recently, that has changed to some degree, and certainly I think although the language is different, I think the arguments that certainly can be made now is that preemption applies generally, assuming you have good subrogation language in both plans, both contracts, applies generally to both. Tim, did you want to discuss that issue further, or did we pretty much cover that question? All good? Okay. Thanks, Tim. I noticed that it is that time, so again, I appreciate everybody attending today. Feel free to certainly call or email us with any additional questions, and I hope you all have a wonderful day. The presentation now has come to an end. Thank you so much.